Willeen Holness, who is a disability activist and a senior lecturer at the University of KwaZulu-Natal. And her presentation is titled Adapting Prevention and Early Intervention Measures and Parenting Capacity Assessments in Neglect Cases Involving Parents with Intellectual Disabilities in South African Children's Courts. The final presentation on this session is titled Towards Reproductive Justice for Women and Girls with Disabilities, a review of Kenya's legal and policy framework. And this is a presentation that will be delivered jointly by Mr. Martin Onyango from the Center for Reproductive Rights. He's the head of Strategies Africa. And the second presenter is Ms. Prudence Mutiso, who is also from the Center for Reproductive Rights and works there in her capacity as a legal advisor for Africa. So just to familiarize you a little bit with the presenters that we have this afternoon, I'm going to read out their bios in turn, starting with Mr. James Tinotenda Ndemera. James Tinotenda Ndemera completed his Bachelor of Laws and Master of Laws with distinction at Rhodes University. He specialized in international criminal courts witness protection measures with a focus on enhancing protection of witnesses in Africa. His current research interests revolve around disability rights, access and refugee protection with a focus on African human rights frameworks. James also works part-time as a research or teaching assistant while interning for non-governmental organizations aligning with his research interests. The second bio that I will read is for Willeen Holness, who will be our second presenter. So Willeen is a senior lecturer at the School of Law, University of KwaZulu-Natal. She holds a BA, LLB from Rhodes, and an LLM from UKZN. She's a disability activist and former public interest lawyer. Her doctoral dissertation with the Center for Human Rights focused on access to justice for mothers with intellectual disabilities in 2 KwaZulu-Natal children's courts, and she was supervised by Professor Charles Ngwena. She writes on access to justice for persons with disabilities, the intersection between gender and disability, as well as children's rights. She seeks to promote the goals of social justice for persons with disabilities, including autistic persons, persons with psychosocial disabilities, and intellectual disabilities through her research, teaching practice, and activism. She is a board member at Shahumna Center, a business skills organization for autistic adults, and a member of the Navi Pillay Research Group. The third speaker that I will present, or whose bio I will read, is Martin Onyango. So Martin is an advocate of the High Court of Kenya with over 12 years of practice experience in Kenya. Martin holds a Bachelor of Laws degree, LLB, from the University of Nairobi, and is currently undertaking his LLM at the University of Nairobi. At the CRR, which is the Center for Reproductive Rights, Martin is responsible for spearheading litigation strategies in Africa at the regional level and nationally in Kenya, Uganda, Tanzania, Malawi, Rwanda, and Nigeria, and supporting program strategy on litigation and related advocacy, supporting the development of capacity building strategies, cultivating pro bono relationships, and representing the center at the regional level. Martin has successfully litigated numerous cases involving the Nairobi High Court Petition 266 of 2015, which is known as the JMM petition, that clarified the abortion law and challenged the withdrawal of technical standards and guidelines for abortion care and ban of health professionals training and medicine for medical abortion. Martin will be co-presenting with Prudence Mutiso, who is also from the Center for Reproductive Rights. And her bio is as follows. Prudence is a human rights lawyer and an advocate of the High Court of Kenya with 10 years post-admission experience. In 2018, Prudence received her master's in law from Georgetown University Law Center, where she participated in the Leadership and Advocacy for Women in Africa Fellowship Program. Prudence received her LLB from Moore University, Eldoret. Prudence has served with local and international organizations where she has represented and advocated for dozens of child survivors of sexual violence and victims of police abuse of power before courts in Kenya. At the Center for Reproductive Rights, Prudence supports litigation to build, enforce, and defend legal guarantees to reproductive decision-making at the regional level and nationally in Kenya, Rwanda, and Malawi. So those are all the bios of our 4 presenters for this particular session. I'd like to, at this juncture to call upon Mr. James Tinotenda Ndemera to give us his presentation.
All right, good afternoon, good evening, good morning, everyone on this platform. I'd just like to ask to get a chance to share my slides. Is the screen sharing?
Yes, we see your slides. Please go ahead.
Thank you.
Thank you.
All right, just a disclaimer, this is my first time ever presenting at academic conference. My paper will be titled Bridging the Justice Gap in the Prosecution of Sexual Violence Crimes Against Women with Disabilities in Zimbabwe. So Zimbabwe has acceded to various international and regional human rights instruments which enshrine the non-discrimination and equality before the law as a fundamental human rights principles for people with disabilities. And to make provision for the welfare and rehabilitation of disabled persons, the country has also domesticated such principles in the Disabled Persons Act. However, the country still struggles with ensuring the effective realization of the rights of persons with disabilities. One such growing problem is that of criminal accountability for sexual violence crimes against women with disabilities. In most cases, investigations are stalled, some issues are not reported, and the women encounter various prejudicial challenges within the criminal justice system. The problem is growing and requires suitable responses tailored to meet their existing unique needs. So just an outline of my presentation. I'll briefly go into show a social reality for conscientization in how these crimes are occurring in Zimbabwe and how the family structure before the judicial system itself, how the family structure is letting down women with disabilities after encountering sexual violence crimes. And then I'll go into a summary of the main salient points that my paper will have. And then I'll just show a brief layout of the presentation and then discuss the issues before proffering the conclusion and recommendations. So on my screen is a story that I extracted from a media report. I'll just read it out. It says, when Miro Tsunga was 12 years old, her grandmother noticed that her stomach was bulging. When she took her granddaughter to the hospital, it was discovered that Tsunga, who has cerebral palsy, was 7 months pregnant. She had been raped. Tsunga, now 15, is severely disabled. She can't walk, she can't speak, and needs someone to feed and bathe her. Unable to communicate, she couldn't tell anyone who had raped her, where or when, and she couldn't receive any counseling to help her cope with what had happened. 2 months after her pregnancy was discovered, she gave birth to a baby girl who was immediately put up for adoption. Tsunga's cousin who was 14 at the time, eventually confessed to the rape. He was arrested and then released with warning. Another example of the social reality, the sight of a pastor is usually a relief to vulnerable persons, such as orphans or people with disabilities. There is little or no suspicion that men of the cloth would at any time prey on those who have invested their trust in them. But this was not the case for Chengetai Mutasa. Her name has been changed for the purposes of the media report, who met her fate when the pastor raped her. Just to highlight that she reported the matter to her family, who decided on an out-of-court traditional settlement of the case, and they only pursued the justice system after the pastor had ran away and refused to pay cultural punishment, so to say. So the experience of women with disabilities in Zimbabwe, they suffer discrimination in many spheres of life. Access to healthcare is limited, education, employment, and access, importantly, access to state justice. Stigma, fear associated with superstition, and discriminatory laws and policies, which also influence responses of the state judicial system or those who are meant to enforce justice for violations against women with disabilities is also increased by these prejudicial thoughts. So I'll just go on to provide a summary of the presentation. So this presentation forms part of a research paper that I'll be forwarding to the for next year. So currently Zimbabwe's judicial system, including the state prosecutorial teams, seem to be facing a Herculean task in compliance with disability rights provisions and accompanying domestic laws, especially equality before the law. Due to the discrimination and stigma linked to disability, sexual violence among women with disabilities is rarely given the deserved attention. This is evident in the gap between incidents and conviction. So my partner, who was supposed to be present also with me today, who ended up not being available, she's from the NGO Feminist Voices Zimbabwe, and they've been doing research on these issues. And she says over the last 2 years, that's 2019 and 2020, the National Prosecuting Authority was only able to complete 9.4% of sexual violence crimes, while in 2020, of the 157 that had been reported, only 147 were postponed. So at the main Rotunda court. So this is only in Harare. So many cases are faltering before the justice system. And the crux of my argument is that the Zimbabwean government, in line with its obligation under international law, will need to do more regarding the protection of women with disabilities when they face sexual violence, abuse, and exploitation. Further, taking into account that amongst family members and guardians, some are the perpetrators. Hence, there is need for special investigative techniques and measures or social security measures that ensure that women with disabilities are placed in an environment where they can speak out on the violence that would have occurred to them. So just a brief layout of what follows next. I'll be just a brief layout of what follows next. Sexual violence crimes so I'm going to just highlight sexual violence crimes and the death of justice in Zimbabwe, and then an overview of the national laws, and then implications of the disparity in the enforcement of the various international and human rights instruments, and then showing how the social institutions such as the family is faltering, and then lastly, rethinking Zimbabwe's justice system. So over the last 2 years, I think I've mentioned this before. The dearth of justice, the lack of justice is affecting women with disability in Zimbabwe, in that families are continuously choosing not to follow the justice system itself. But this means that women with disabilities end up not having their cases heard and end up not receiving justice, which makes the Zimbabwean system a haven for such abuses and continues to ensure impunity for such actions. In some instances, victims are not aware even of how they can report the cases, as we saw in Tsunga's case that I showed earlier on, that sometimes they don't even have the ability to communicate such cases. Further, the family will only seek justice when perpetrators fail to pay cultural punishments for their actions. Another example from a media report, a superintendent in the Zimbabwe's police system says that there are no clear statistics or cases of sexual abuse against women with disabilities because they are not just noted down, yet it's a growing problem in society. So an overview of the national laws. So currently in Zimbabwe, just a recap, violence against women as defined by the United Nations General Assembly Declaration on the Elimination of Violence Against Women includes rape and violence that results in or is likely to result in physical, sexual, or psychological harm or suffering to women, including threats such as coercion, arbitrary deprivation of liberty, whether occurring in public or private life. The Sexual Offences Act in Zimbabwe defines rape as any person who, whether married to another person or not, without the consent of that person, inserts or penetrates the other person's genitalia. And then the criminal law codification also has a similar definition. But importantly, Zimbabwe having a Sexual Offences Act highlights the problem in society. And then furthermore, the Constitution of Zimbabwe does highlight that the treatment of persons with disabilities and ensures that persons with disabilities are supposed to, that the state, it obligates state institutions to ensure that the rights of persons with physical or mental disabilities, in particular, their right to be treated with dignity, should be improved. And then the Disabled Persons Act, Section 8 notably says that the prohibition of denial to disabled persons of access to public premises, services, and amenities should not be allowed, while it also prohibits discrimination against persons with disabilities. Yet the practical reality, as we have seen in the cases that I highlighted before, is that state institutions or state personnel meant to ensure justice seem to be untrained or unknowledgeable or have prejudicial thoughts that make them not implement the laws that are available or the promises that the legislation has laid out. So the implications are that there's a disparity in the laws and the actual implication. The state basically is not equipping investigators adequately. Furthermore, society and family, which seeks alternate avenues before relying on the law, drives impunity, resulting in a high deficit of incidents and prosecution. So just to highlight some of the laws that Zimbabwe has acceded to, the international legislations, international instruments. So Zimbabwe has accepted the African Charter on Human and People's Rights. And from that charter, we can glean from Article 3, which highlights the right to equality before the law of all persons and equal protection of the law. Then we can also glean from Article 18, which provides for family protection, for the protection of the family, but importantly, vulnerable groups, including those who are disabled. Furthermore, the protocol of the African Charter of Human and People's Rights, the Maputo Protocol, Rights of Women in Africa, we can glean importantly Article 8, which provides for access to justice and equal protection before the law. We can also glean from Article 23, which provides for special protection of women with disabilities. And although the country has not yet acceded to the African Charter of Human and People's Rights on the rights of persons with disabilities, there is some indication of parliamentary support, and guiding principles that Zimbabwe should be applying are from Article 5 on non-discrimination, Article 6 on the right to equality, Article 7 on equal recognition before the law, Article 13 on access to justice, and Article 15 on accessibility, and Article 27 on special protection for women and girls with disabilities. So I will briefly discuss or go into the conclusions and recommendations. So women, it's clear now that women with disabilities in Zimbabwe should no longer remain invisible victims of sexual violence. Therefore, the paper is going to argue that Zimbabwe should introduce special laws and special mechanisms to ensure the enforceability and accountability for sexual violations against women with disabilities. The recommendations focus on the unique needs of women with disabilities who experience sexual violence, and they should be implemented alongside the good faith interpretation and application of international instruments. It was stated before, I think it was Professor Charles Nguena, on balancing how societies or how conservative societies in Africa view sexual rights issues. So I would then argue for good faith interpretation and application of the international instruments. And the paper will also profile procedural measures relating to the interaction that the women have with the state's investigative and prosecutorial arm of the judicial system, which should be age sensitive. We should also cater for the specific or different disabilities to avoid situations where the women cannot describe what they've gone through. And then I would also argue for the introduction, something controversial, but for the introduction of secondary prosecution or liability for families who decide to dodge the justice system when faced with situations of sexual violence where could it be a family member who has done the act, or a pastor, or whoever it is. This would ensure that the adverse decisions that are taken by such families, while not being in the best interests of the disabled person, are not taken. I would conclude here. Thank you.
Thank you so much, Mr. Ndemera, for that presentation. I think it was a depiction of the fact that, you know, in the morning we were dealing with the right, you know, to sexual and reproductive health and rights for persons with disabilities. And now I think we've done a shift to looking at the other side of the coin, so to speak, and looking at the right of persons with disabilities to freedom from violence and some of the failings that are in the justice system, particularly in Zimbabwe. So thank you so much for that presentation. I think the next presentation also looks at interactions within the justice system that are relevant to the right to sexual and reproductive health and rights for persons with disabilities. So I'd like to welcome Ms. Veline Holness to speak to us about adapting prevention and early intervention measures and parenting capacity assessments in neglect cases involving parents with intellectual disabilities in South African children's courts. Ms. Holness, you're most welcome.
Sanbonani, Jumbo, it's so lovely to be here. Thank you so much. If I can check with the sign language interpreter that she can see me with a thumbs up and hear me well. Fantastic. I am very happy to be here today. I'm talking to you today about the role of social workers. And social workers are involved in children's courts, which in other jurisdictions will be known as family courts. And this is instances where we find that the parents with intellectual disabilities are thought to be perpetrators of neglect. And then social workers will intervene and remove the child from the family based on that assumption and place them in alternative care. That is then when statutory proceedings ensue, and the Children's Act in South Africa then formulates the legal response that goes from there. So as you can imagine, social workers are the gatekeepers for social service provisions to families, including to those with disabilities. They may prejudge parents with intellectual disabilities as being incapable of parenting their children, especially where support services are not provided and are not adapted. And here we refer often to prevention and early intervention measures and parenting capacity assessments. So the aspect around intersectional discrimination that women with disabilities face, and the aspect around associational discrimination that is also faced by their children is quite acute here. Women are thought to be passive and dependent, and that they are cared for by their children. This is known as parentification. And instead of being seen as fulfilling their role as capable caregivers. So the assumption is then underpinned that they are the perpetrators of this abuse or neglect, and yet many disability studies show us that disability is not a causal factor in child neglect or parenting inadequacy. So in the chat box, you will see that I have posted a few questions, 5 questions, in fact, and those questions are just to help the participants to identify whether there are issues in their jurisdictions that might come up that have similarities with what is happening in South Africa. So these ableist notions around parenting are related to ideas around myths on sexual reproductive health rights. And Dr. Hunt earlier today spoke about a lot of those, the lack of sexual agency and desire, being less sexual than non-disabled persons. And then of course, these impact on the right to family life in particular. And eugenic notions are embedded in policies. And in South Africa, we still have forced sterilization, therefore non-consent of a person with an intellectual disability still being practiced in South Africa under law. So the control and the regulation of the sexuality of persons with intellectual disabilities still continue, both by the families involved, especially those that have a caregiving function, and also by the state. So mothers with intellectual disabilities are considered to be or presumed to be incompetent as judged by assessments and reports that the social workers prepare or psychologists will prepare to court after they investigate the family circumstances. So the assessments and these reports carry significant evidentiary weight, and they are difficult to challenge. The result is that the children's courts will rubber stamp these diagnostic, prognostic decision-making in the assessments, and therefore the results will be almost a fait accompli, that the child will be removed and returned to the family is usually not something that happens. That is an exception to the rule. So the background that this paper proceeds against is our international law obligations, and those some of the other presenters have identified already. They are just shortly prohibition of discrimination on the basis of family, parenthood, and disability, and of course the requirement of reasonable accommodation. That's in the CRPD, the CRC, as well as the African Disability Protocol, amongst others. Then equality before the law, requiring positive steps to be taken to enable de facto equality, and the recognition of legal capacity and supports to exercise that where needed, together with safeguards to stop abuses, and then the right to family life being recognized, including, and this is crucial, measures that should be provided to families to assist them to perform their child rearing responsibilities. There's an injunction in our international law that says we may only separate children from their parents when competent authorities, after judicial review, determine that the separation is needed under the relevant laws and that it's necessary in the child's best interests. But you may not separate children from their parents on the basis of that parent's disability. And then the last aspect is access to justice, which includes the provision of procedural accommodation in courts, and also requires training of those involved in the administration of justice. And this has been interpreted by the Committee on the Rights of Persons with Disabilities as including social workers and health workers. So they too need to be provided with a relevant training to promote access to justice for these persons, including around procedural and reasonable accommodation. So what is the kind of support that we are talking about that these families require? The CRPD committee again has given us guidance, and they say it must be community-based, adequate, accessible, and available, and appropriate to the goal of facilitating child rearing responsibilities. It can include personal assistance, grants, adapted social services, and it also includes access to information, guides in easy read format on what to expect in family courts, how to lay complaints against service providers, and then also activities on daily living, including instrumental activities to parents, providing daycare or respite services, childcare assistance, personal assistance, supported housing. The list is a very long list. But crucially, for parents with intellectual disabilities, we talk about adaptations to social services, and that would be repetition of information and training, modified parenting skills with hands-on instruction in their natural environment. We require in-home modeling, parent modeling, and tailoring parenting educations to the needs of the parents themselves. Many legislations around the world include prevention and early intervention measures in either their children's legislation or their disability legislation. In South Africa, it's contained in the Children's Act. And this is usually aimed at strengthening the family's capacity and self-reliance to address problems before they will lead to statutory intervention. So early intervention looks at identifying children who are at risk of harm to prevent the removal into alternative care, and is aimed at preserving the family structure. Unfortunately, these support measures are not usually adapted, they are not usually accessible, and reasonable accommodation is not usually embedded as a right in the provision of these services. And lastly, the monitoring and evaluation is usually highly problematic. And when I'm talking about monitoring and evaluation, I'm talking about both the supervision of the social worker within the social services provided by the relevant government department or NGO providing social services, or by the presiding officer in the family courts in terms of checking whether this veritable shopping list of measures that have been identified by the social worker is actually being provided to the child and the family. Have they participated in those? Are they adapted? And what is the impact of those measures? So social workers provide these reports to court, and the court itself may also order professional reports to be provided to it to investigate the child or the parent's circumstances. It can be provided by a social worker, psychologist, or other mental health professionals. In practice in South Africa, the social worker does so. And this report is evidence that our mere production is an authoritative opinion and is admissible to the court. If a person's rights are prejudiced by this report, then they should be provided with an opportunity to cross-examine the author and to refute these statements. Now, you can imagine if a parent with an intellectual disability is not legally represented, and if they don't understand the proceedings, and if reasonable and procedural accommodations are not made for them, then it becomes highly problematic in terms of how they will be able to cross-examine this. Right. So we ask ourselves whether these capacity assessments meet ethical guidelines. Are they fair, valid, and reliable, or non-discriminatory? Do they identify the support and reasonable accommodations that are needed by the parents? Remembering that the children's courts in South Africa are inquisitorial, so the magistrate has an important role to assist the parties before it, and we also have a requirement that court rules should be provided to avoid adversarial procedures and to include appropriate questioning techniques for children and those with intellectual and other disabilities. And yet, these rules have not yet been promulgated. As early as 2 years ago, new law reform ensued for changes to the rules in the Children's Court. And again, despite this provision in the Children's Act that such rules need to be formulated, this has not yet happened to date. So these Children's Court orders are not judgments. Once a court decides that a child is removed from the family and placed in alternative care, they do not provide a list of reasons. They have no accountability other than the party being able to either review or appeal the decision if they wish, but in practice, this hardly ever happens. So this archival study, which is based on my doctoral research, looked at the court records of 2 children's courts in Durban and Pietermaritzburg in the KwaZulu-Natal province of South Africa. And out of the 5,000 cases before these 2 courts for the period 2010 to 2014, we find that there were only 244 neglect cases. So only 4% of the cases before the children's courts were in fact neglect cases. 28% of these neglect cases cited parental disability as relevant in the social workers report. So 27 of the parents had intellectual or psychosocial disabilities identified, and they experienced a number of barriers, such as heightened poverty, and then, of course, the stereotypical assumptions made by social workers about their parenting ability. There is a diagram on the slide, number 4, that shows the ratio of general neglect, disability, and intellectual disability cases before these courts. What I'd like to share with you next is just a snapshot of the kind of cases that come before the children's courts in South Africa. And this is the national picture. This graph on slide number 5 shows you the children in need of care and protection cases that includes abandonment, neglect, sexual abuse, and so on. By 2017, the latest statistics I was able to find, there were around 65,000 cases in the children's courts around the country. Compare that to the next slide, number 6, where you will see the most recent statistics from 2019 show 386,000 foster care grants being processed in South Africa. That number does not include approximately 200,000 to 300,000 lapsed foster care grant orders from the year 2011, which has brought about law reform around social assistance and foster care grants for orphaned and abandoned children, especially those in kinship care arrangements. Why am I showing you this big picture? It's because of the institutional barriers that social workers face. They have a high caseload. They are usually staffed in underfunded NGOs, providing statutory and non-statutory services. There are insufficient social workers provided as a workforce in South Africa. And then, of course, there are financial capacity constraints in the NGO sector. So the knock-on effect of the foster care grant crisis in South Africa means that social workers are not spending time and effort on neglect cases, nor do they then spend their time on adapting their services to vulnerable and at-risk populations. So in this study, I identified a number of barriers to access justice, and I am only in this paper able to look at the last 2, and that is the stereotypical beliefs of court personnel and social workers. And this is not from perspectives gleaned from these social workers or presiding officers, but from the archival records, the evidence put on court files. So what are these stereotypical generalizations? In the social work reports, 4 indications were found, and these correspond with international literature on this phenomenon, that the mother's supposed lack of her capacity to change is problematic, that she is unable to learn new skills required to be a good enough parent. Second, that she displays characteristics that are assumed to be universal to persons with intellectual disabilities, such as lack of responsibility or insight. Third, that her personal circumstances cannot improve and she cannot obtain remedies for her problems. And fourth, these reports have categorical statements that disability, especially intellectual disability, equates to incapability or inability to parent. So the social work reports would say things like, she has no insight, prognosis for recovery is poor. Because of her low intellectual functioning, she's unable to be a parent. So the ableism and the diagnostic prognostic thinking is evident in the social work reports. So some of the findings from the review of the court cases show that the parent's disability diagnosis is not often clear-cut, and sometimes there are conflations. They will say a person is mentally challenged when they mean that a person has a psychosocial disability, such as depression, for example, when in fact they meant to say an intellectual disability or vice versa. Then the parenting capacity assessments are not usually offered in these cases. And in one instance, it was offered to the court by a psychologist, but the psychologist indicated it was not for forensic purposes, and the report was incomplete. The professionals also did not testify in court after these reports were put before the court. The evidence of the child's circumstances usually is provided in medical reports corroborating harms such as malnutrition, for example, but the weighing of risk and protective factors are not evident in the social work reports at all. In 14 instances, the social work reports indicated that parenting skills programs were needed as a therapeutic intervention, but only in one case did the social work report subsequently indicate that the parenting skills program was offered, and it had never been offered as a prevention and early intervention measure. So it almost comes a little bit too late. And in none of these cases were these programs adapted for the needs of persons with intellectual disabilities. Quite starkly, these reports did not identify communication challenges or the need to implement measures to support the parents' communication, and none were provided with easy read material. The social work reports are quite lengthy, so it's quite difficult to work through for the average lay person. So for a person with an intellectual disability, the volume of information would be a lot to work through. And of course, they were unrepresented as parents, so they were not willingly offered this opportunity to cross-examine the proceedings. Right, so some of the recommendations that come from the study look at the need to adapt prevention and early intervention measures. We have guidance from the Committee on the CRPD that indicate that such measures should be community-based, adequate, accessible, available, and appropriate for the goal of facilitating child-rearing responsibilities. They are required to be adapted and to offer reasonable accommodation when needed. But in practice, this does not happen. In South Africa, we have norms and standards, but these norms and standards, including the legislation, prioritize funding for services to children with disabilities and poverty alleviating measures. And we know in this resource-scarce world we live in, some prioritization is always going to be necessary, but parents with disabilities are always left off the list. Crucially, the review of these court files showed that the magistrates, the presiding officers, did not supervise or identify monitoring and evaluation of whether or not these measures were in fact offered. And of course, if they are not schooled in understanding the need to adapt these offerings, then that is also going to be a huge barrier. The next issue is parenting capacity assessments. Now, parenting capacity assessments in themselves can be discriminatory if we are only offering them for persons with disabilities, because then they are directly discriminatory, right? So what we do require is to modify them to incorporate parenting adaptations. And if we want to be compliant with sections 12 of the CRPD, looking at legal capacity and supports to exercise decision-making, then we need to also identify those supports as well as the supports in child rearing that are necessary for the parents to effectively do their child rearing obligations. So if we are going to allege that a parent with a disability, much like any other parent, have some deficiency in their parenting skills, that they are not adequate parents and the child's best interests are not being met, we require explicit evidentiary support. And we also require existing and natural supports in the assessment to be provided. Self-evidently, specialized training is necessary of the assessors, including of social workers, and we need to look at the kind of codes of ethics, guidelines, and adapted assessment protocols that can make this a reality. The magistrates require critical evaluation of the evidence, and they need to be well-versed in the kinds of reasonable accommodation that is offered. But if court rules don't give them this guidance to begin with, magistrates are left at sea. And therefore, we also require our court rules to provide for reasonable accommodation measures as well as procedural accommodation. So We know that parenting capacity assessments can be useful tools, but we also identify that we need to be very careful of ableism creeping into these parenting capacity assessments, because they on their own can be blunt instruments and they are not flawless predictors of parenting ability. Their validity needs to be questioned from a Eurocentric perspective that is often imbued in these kind of reports, around the professional's own biases, knowledge, beliefs, and values about parenting. And we need to similarly also embed disability perspectives around the best interests of the child, including around kinship care arrangements for children. So parenting capacity assessments, therefore, needs to be quite clearly decoupling the disability of the parent from the parenting of the child. And then the last two aspects, access to information to the parents about the court process and complaints procedures available to them should be made available. And on legislative reform, there is a huge gap in our Children's Act, and the South African Law Reform Commission is currently engaging on drafting potentially a disability bill. That is what is mooted before them for South Africa. And in those, we need very clear provisions that identify the need for clear evidence of parenting deficiency that is not based on disability status, and that we provide parents with the relevant supports that they may need. And in that way, we can hopefully promote access to justice for parents with intellectual disabilities in our children's courts and assist them to meet the best interests of their children. Thank you.
Thank you so much, Ms. Holness, for that presentation. I think you did a great job in of highlighting, some of the potential pitfalls in the processes that go on in the children's courts in South Africa for parents with intellectual disabilities. I think a lot of times there is a lot of focus on when we're talking about sexual and reproductive rights, there's a lot of focus on, the right to actually engage in sexual activity. But then the other side of it, which you have, I think, so competently brought up and highlighted, is that there's also the right to parent, the right to reproduce, the right to and to bring up your own children in the way that you see fit. And I think we're grateful that you've highlighted for us some of the issues that are in the courts, in the court system, and you've also brought up, I think, some excellent recommendations for a way forward. So we're grateful to you for looking at it from that particular angle. So at this stage, I'd like to invite our last two speakers for this particular session, who will speak to us on the topic towards reproductive justice for women and girls with disabilities, a review of Kenya's legal and policy framework. Mr. Martin Onyango and Ms. Prudence Mutiso, you are most welcome to take the floor. Thank you.
Thank you so much, Diana. And just to confirm with the sign language interpreter that you can hear me well and see me as well. All right.
100%, madam. I can see you, and you are even audible. Thank you.
Fantastic. Thank you very much. Good afternoon, ladies and gentlemen. My name is Prudence Mutiso, and it's my honor to share this presentation today with my colleague, Mr. Martin Onyango, the head of legal strategies at the Center for Reproductive Rights. Our presentation will discuss the response of Kenya's legal and policy framework towards the reproductive autonomy for women and girls with disabilities. This presentation will provide an overview of Kenya's disability rights framework with a focus on the reproductive health, legal and policy framework. The presentation will also provide an assessment of the inadequacy and discriminatory aspects in the legal and policy framework and outline the barriers towards reproductive autonomy for women and girls with disabilities. We will also provide recommendations for legislative action and implementation to fulfill the reproductive healthcare obligations for women and girls with disabilities. How does the disability prevalence look like in Kenya? Both the 2009 and the 2019 Kenya census show a high prevalence of disability among women, inclusive of girls, compared to men. For example, the 2009 census reported 3.5% of women have a form of disability compared to 3.4% of men. A similar trend appeared in the 2019 census that shows that 2.5% of women have a form of disability compared to 1.9% of men. And with a population of 53.7 million of Kenyans, the census only showed about 900,000 men and women having a form of disability. The Kenya National Bureau of Statistics reports that inaccuracy in reporting and stigma may have contributed towards the lower figures in 2019. Is disability-based discrimination deep-seated in the Kenyan society? One may ask. The Kenya National Bureau of Statistics acknowledged that stigma may have contributed to the lower figures in 2019, as shown in the previous slide. These sentiments were echoed way back in 2012 when the Kenyan government admitted the entrenchment of disability-based discrimination in stereotypes that portray persons with disabilities as burdens and curses, something that still happens to date. But all the same, over the last 2 decades, Kenya has made attempts to address discrimination based on disability. In 2003, Kenya's parliament enacted the Persons with Disabilities Act, a law that provides for the rights of persons with disabilities. In 2010, Kenyans adopted a new constitutional dispensation that recognizes and safeguards the rights of persons with disabilities and prohibits direct or indirect discrimination based on disability or health status. The Constitution of Kenya also provides that every person, including persons with disabilities, have the right to the highest attainable standard of health, including reproductive health care. And Kenya has over the years enacted laws and policies to respond to the sexual and reproductive health rights of women and girls, including those with disabilities. Having acknowledged the deep-seated discrimination that persons with disabilities face, in 2012, the government of Kenya proposed amendment of the Persons with Disabilities Act to eliminate discrimination against persons with disabilities in matters relating to marriage, family, and personal relations. The government also stated that the issue of legal capacity remains a challenge for persons with mental and intellectual disabilities. The government of Kenya committed to review its laws to shift from substituted decision-making towards supported decision-making for persons with disabilities. 9 years since the making of the commitments and 11 years since the promulgation of the Constitution of Kenya, the government is yet to fulfill these promises. So what are some of the international obligations that Kenya has? As Ms. Judith said in the morning, Kenya ratified the Convention on the Rights of Persons with Disabilities in 2008, and Article 2, Sub-Article 6 of the Constitution of Kenya provides that any treaty or convention that has been ratified shall form part of the law of Kenya, and this holds true for the Disability Rights Convention. As a state party to the CRPD, Kenya has an obligation to fulfill and realize disability rights for all individuals. Because of existing barriers, the CRPD expressly provides standards to overcome the barriers towards access to health for women and girls with disabilities. To begin with, Article 5 of the CRPD affirms the equality and non-discrimination before the law and requires member states to take measures to ensure the full and equal enjoyment of all human rights and fundamental freedoms for women and girls with disabilities. Again, in support of autonomous decision making, Article 12 of the CRPD is instructive as it recognizes legal capacity of persons with disability on an equal basis with others. And as our keynote speaker stated in the morning, and Professor Charles Ngwena, Article 23 and Article 25 of the CRPD reinforces the right of persons with disability to attain the highest standard of healthcare, including in family relations and sexual and reproductive health without discrimination. Article 25 set the standards for access to reproductive healthcare across the range of disabilities. Besides the CRPD, Kenya is party to other treaties as well, including the Convention on the Elimination of all forms of discrimination against women, CEDAW, the International Covenant on Economic, Social, and Cultural Rights, and the Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, the Maputo Protocol. All these treaties provide reproductive healthcare obligations and reproductive healthcare protections for women and girls with disabilities and are binding on the government of Kenya. It is important to mention that in 2018, the African Union adopted the Protocol to the African Charter on Human and People's Rights on the Rights of Persons with Disabilities, and though not yet in force, Kenya is among numerous countries yet to sign the protocol. It is worth highlighting that the protocol creates progressive reproductive rights obligations, and as a state party to the African Charter and a champion of disability rights, Kenya has not provided persuasive justifications for its failure to sign the Disability Rights Protocol. So how has Kenya responded to the reproductive autonomy for women and girls with disabilities? As I have mentioned, before Kenya ratified the CRPD in 2008, Kenya already had the Disabilities Act in existence. And the Disabilities Act provides protection for persons with disabilities, but does not provide specific protections on access to sexual and reproductive health. This particular law mandates the National Council for Persons with Disabilities to monitor the provision of healthcare to persons with disabilities and to ensure that the services are devoid of any form of discrimination. Over the years, the one thing that the Disabilities Act has done is to promote the recognition of persons with disabilities in numerous health-related policy documents. Additionally, Article 54 of the Kenyan Constitution provides for the equal recognition and non-discrimination of persons with disabilities in all spheres. Specifically, it recognizes dignity and respect, reasonable access to all places, the use of sign language, braille, or other appropriate means of communications and devices to overcome constraints arising from a person's disability. We argue that the constitutional provisions read together with Articles 5, 12, 23, and 25 of the CRPD provide a strong legal framework for the advancement of reproductive autonomy for women and girls across the range of disability. Owing to the acknowledgement of discriminatory aspects in its legal framework, Kenya has made attempts to update its disability rights legal framework with the introduction of the Mental Health Act Amendment Bill of 2020 and the Persons with Disabilities Act Amendment Bill of 2020. The Persons with Disabilities Act Amendment Bill recognizes the right to sexual and reproductive health for women, and this includes the right to control their fertility. The bill also criminalizes any person or any acts that are meant to abuse, violate, or exploit any person with disability. Conversely, the Mental Health Bill still allows for substituted decision-making and provides for restricted legal capacity. As we shall hear later during this presentation, Kenya should take steps to harmonize its laws to fulfill its reproductive health obligations for women and girls under the CRPD and the Constitution. I now invite my colleague, Mr. Martin Onyango, to take us through the rest of the presentation. Over to you, Martin.
Thank you, Prudence. And you have done a review partly of the Kenyan healthcare, legal reproductive healthcare regulation. And so what I will do in my remaining minutes is to try and discuss the reproductive healthcare laws and policies in Kenya, and also try to highlight where the problem lies. Where do we have a problem within this particular framework? And
I'm sorry, can I ask you just to pause? It seems we don't have a video for our sign language interpreter. Can I ask the sign language interpreter to please turn on your video?
My video is open.
Is it open? Okay.
Yes, it's open.
Just that we can't see you.
Maybe
I wonder if we could spot
switch it off and on again. Can you see it
Yes.
now?
Okay, I can see you. Can I ask, please, the communications team to spotlight the sign language interpreter? Okay. Okay, I think there's a spotlight on you now.
Yeah.
Yes, please go ahead. My apologies for the disruption. Go ahead, please, sir. I don't know if you can hear me, Mr. Onyango. Mr. Onyango, I don't know if you're still online. Okay, we seem to have, no, but I can see him here. Ms. Mutiso, would you know if Mr. Onyango is still online with us?
Diana,
Yes.
if you can hear me, Mr. Martin is, he says he's online, so he's trying to talk. So let's just give him a few seconds.
Okay.
Yeah.
Okay, we'll wait a few minutes.
Hello, Diana. Martin says that he can hear you very well. And I don't know what the problem is.
Are you
Because
not
it seems-
able to proceed with the rest of the presentation? Because we are unfortunately running out of time.
Yes. Okay. Yes, we can hear you, Martin, now.
Okay. I think we can proceed, and I'll try catch up with the lost time. As I was mentioning that to address the reproductive health needs of its population, Kenya enacted a robust reproductive health legal and policy framework. First, the comprehensive constitutional framework provides for equality of all individuals and prohibits discrimination based on disability or health status. In particular, Article 26 of the Kenyan Constitution, for example, permits abortion when, in the opinion of a trained health professional, the life or health of a pregnant woman is in danger, or if permitted by any other written law. The Constitution of Kenya obligates the government to progressively realize the rights to reproductive health care while having regard to vulnerable groups or individuals. And in particular, Article 45 of the Constitution further recognizes the right to marry based on free consent of the parties. The Constitution buttresses the right to equal treatment of all individuals, including women and girls with disabilities. And to give effect to the constitutional provisions on the right to health, including reproductive health care, the government of Kenya has developed numerous laws and policies, which includes a health law called the Health Act, a national reproductive health policy, including a reproductive health policy for adolescents, guidelines for reducing maternal mortality from unsafe abortions, among other policies. The Health Act makes provisions on access to reproductive health information and services for every person, including persons with disabilities. In particular, Section 4 of that law provides that the state has the responsibility to ensure the realization of health needs of persons with disabilities, which includes access to reproductive health. In addition, the National Reproductive Health Policy of 2007, which the government of Kenya is currently trying to review, and the Adolescent Health Policy support provision of disability-friendly sexual reproductive health information and services. It is commendable that Kenya has taken steps to realize sexual and reproductive health needs of its people, including those with disabilities. However, while the CRPD has created a progressive obligation for states, women and girls living with disabilities in Kenya experience a reality that does not fall within the promise. In particular, the experience in Kenya has demonstrated a negative impact of a protectionist legal framework without consideration for the sexual needs of women and girls with disabilities. The Sexual Offences Act, for example, similar to many countries, prohibit sexual relations with adolescents and persons with mental or intellectual disabilities. The Act does not make room for evolving capacities of adolescents, and all sexual activities for anyone, including girls with disabilities and below the age of 18, is illegal and criminalized. As a result, adolescents have been prosecuted for unlawful sexual acts with fellow adults. The strict law has led to minors receiving long prison sentences for engaging in non-coercive consensual sexual activity, and inconsistencies in the jurisprudence on adolescent rights in Kenya has created a further problem for access to sexual reproductive health and rights, including for adolescents with disabilities. Second, the question of legal capacity, again, fails to meet the standards under Article 12 of the CRPD, and this has been discussed in detail. The baffling admission of Kenyan government that Section 146 of its penal code, instead of protecting persons with mental disabilities, not only does Section 146 use derogatory terms to refer to persons with intellectual disabilities as idiots and imbeciles, which denies them the dignity. The provision also perceives women and girls with disabilities as asexual, denying them their right to sexuality, contrary to the CRPD. Third, but not last, is that the right to marry and establish a family for women with mental or intellectual disability is threatened by the Marriage Act, in particular Section 11 of the Marriage Act, which presumes that persons with any mental disorder or mental disability, whether temporary or permanent, cannot consent to a marriage. Of course, again, the grounds for nullification of a marriage include insanity without further elaboration of that provision. The inadequate implementation of the existing reproductive health policies and laws compound the problem on access to reproductive health for women and girls living with disabilities in Kenya. And as already highlighted, it is therefore necessary that if Kenya is to make the necessary steps, one, the CRPD and the Constitution that provide an opportunity for Kenya to lead and champion women and girls' rights with disabilities to access reproductive autonomy. The blanket assumption that sexual and reproductive health rights needs of persons with disabilities is homogeneous must be dropped from all government intervention, and access to information and services should be designed to meet the needs of each group. As currently undergoing, the review of laws that limit legal capacity should continue, and the government should ensure that all laws that limit the capacity of women and girls, including those with reproductive health, are reviewed. Finally, the government should undertake measures to combine prejudice that restrict women and girls' access to reproductive health care. For example, all health policies by the Ministry of Health on access to information and access to services should reflect the respective needs of the various groups with disabilities. The government should make certain the full implementation of Article 26 of the Constitution on access to safe and legal abortion for all persons and the access to healthcare, including reproductive healthcare services for all persons, including women and girls with disabilities. The Parliament of Kenya should also pass the proposed amendments to the Persons with Disabilities Law to ensure that it aligns with the Constitution and also it aligns with the CRPD. Finally, Kenya should lead in signing and ratifying the Disability Rights Protocol to provide increased protection to women and girls with disabilities. In ratifying the protocol, ratifying the protocol will not occasion additional financial obligation beyond those already occasioned under the existing law in Kenya. Thank you for your time.
Thank you very much, Mr. Onyango, and Ms. Prudence Mutiso for that very comprehensive presentation on Kenya's legal and policy framework relating to sexual and reproductive rights for women and girls with disabilities in Kenya. So I think at this stage, I'd like to give all participants a chance to ask any questions that they may have. Again, you're very free and you're very welcome to add any questions that you might have for any of our 4 presenters. So far, I do have a couple of questions that were in the chat. So I'd like to just read these out. So the first one was directed to Mr. Ndemera, who gave the first presentation. And it reads as follows. Great presentation, Mr. Ndemera. I wish to recommend strengthening the capacity of all justice sector institutions, including the judiciary, with regard to how best to deal with sexual offenses against persons with disabilities. There is also the issue in most jurisdictions of the need for a higher degree of proof for sexual offenses, such as corroboration, which normally deters sexual offenders from pursuing their cases to secure their right to an effective remedy. What would be your comment in the context of Zimbabwe? So that's the question directed towards Mr. Ndemera. There was also another question directed to Ms. Veline Holness. And it reads as follows. It is clear that South African courts are not equipped to deal with matters in which either parents or children have a disability. How can we adequately train court officials to deal with such matters? There seems to be a lack of willpower to transform the legal culture. And then there was another question in the chat box, which was also answered in the chat box, but for everyone else's benefit, I'm going to read out the question as well as the answer. The question was also directed to Ms. Veline Holness, and it was, where can one acquire the draft disability bill by Law Reform Commission in South Africa? And the response from Ms. Holness was, the South African Law Reform Commission is currently involved in formulating a legal response to domesticating the CRPD. One of the options is a disability bill. Comments have been received from the public on the issue paper and the process is still underway. So for now, there is no draft disability bill, but we are hopeful that one will be drafted. It is a monumental time for South Africa in relation to disability rights, and time will tell what the South African Law Reform Commission will deliver on this score. So far, those are the questions and comments that we have. Can I now give the presenters an opportunity to address these? So I see somebody's got a hand. Is it Dr. Kenneth Muzata? Dr. Kenneth, if it's a question, you may go ahead and ask your question.
Okay. Thank you very much. Thank you very much for the opportunity and for the good presentations. I would like to direct my, concern to the first presenter and perhaps the second. Talking about abuses for females with disabilities. And that's where my concern really is. How do we define, abuse, and especially sexual abuse for females with disabilities? If somebody impregnates and accepts, do we still have to arrest such kind of a person? I am thinking that perhaps people who abuse, the so-called abuse in connotations, it's not well defined yet. The people who abuse persons with disabilities avoid to accept responsibilities because of certain stereotypes that go with the disability, and also because of some stringent, rules and laws that have been put in place that persons with disabilities would actually not make decisions on their own. So the question that comes to my mind again is, do persons with disabilities have the right to sexual reproductive life? Do they have the right to have choices of having maybe sexual relationships to have partners. If rape of a person with disabilities can be considered as abuse, okay, not really rape. If sex with a person with a disability is considered as rape, do these people really have the right to make their own decisions? And so with these questions in mind, at the end of the day, we have an example, for example, in Zambia, where one person is actually battling with a case in court. The reason is that of attempted rape. And yet, perhaps we wouldn't call it rape. And that is why I asked the first presenters to define that in the context of the laws of Zimbabwe. The person says, actually, he didn't actually attempt to rape. What gaps do we really have in terms of sexual reproductive health for persons with disabilities? And how can we actually fill such kind of gaps? I think those concerns really need to be addressed. Thank you very much.
Thank you so much, Dr. Mzata. I will also ask Harry Chikasamba. I'll take one more question from Harry, and then we'll give the presenters an opportunity to respond. Harry, please go ahead. Harry, I don't know if you've heard me, but you have the floor. You can ask your question. No, we cannot hear you. Perhaps while Harry maybe tries to sort out the sound on his laptop, I'll take Ali Jukun. I'm not sure if I've pronounced that correctly. Okay, so it seems there's technical glitches all around. Let's turn now to the presenters and give them an opportunity to address the questions that I've already shared. Thank you. We can start with Mr. Ndemera. I think the first question was for you.
Okay, thank you. If I noted correctly, the first question relates to the higher degree of proof. I'll respond and say some of the recommendations being explored include the introduction of specialized social workers and state attorneys who are able to assist women with navigating the judicial process itself, and perhaps also ensuring that the police, judicial officers, medical officers, and judges receive adequate training in the rights of women who would have experienced the sexual abuse. So perhaps one could include special educators who can identify the disability accurately and provide support or other accommodations to help in navigating the judicial process itself. And then the other question, I think it was from Dr. Kenneth. Well, I think what you were saying will also relate to questions of consent. So perhaps we'd have to then look at the context of the person whose rights would have been violated. So the context, can you say in that position, they can give consent? We also look at the age. If it's a person who's below the age of consent, they are disabled, they can't speak, or for example, the Tsunga example that I showed where she's got cerebral palsy. Yeah. So perhaps those are some of that's the context that the law or the judicial officers would have to take into consideration when determining yeah, when determining whether one's rights would have been violated. Yeah, thank you.
Thank you so much, Mr. Ndemera. Ms. Holness?
Thank you very much. So the question around the South African legal system, and especially our courts not being equipped for dealing with parents and children with disabilities, and how do we adequately train court officials? Well, first of all, we need to understand that court officials don't just arise organically. They are trained in our law schools, and our law schools need to transform their curriculum to decolonize disability even in their teachings. So the law schools are responsible for incorporating disability curriculum. How do you adequately represent a client with a disability? How do you advocate for a client with a disability in court procedures that might be unaccommodating and procedurally unfair? How do you challenge those? And then, of course, ensuring that we have more legal representatives available to not only indigent persons, but persons with disabilities who may require such representation. Then we have other legal bodies like the School for Legal Practice. All legal practitioners are required to undergo mandatory legal training before they are admitted to the profession. Those include practice management courses and can include also on disability sensitivity and reasonable accommodations and representation of clients with disabilities. Our bar councils, our law council, and then, of course, the South African judiciary's educational arm, that institution also in its bench book and other continuous trainings can provide the relevant training as well. But what is absent from South Africa and many other legal systems is court rules that provide for the steps and the procedures to follow to ensure persons with disabilities can participate in legal proceedings, whether it's criminal proceedings, children's courts, family courts, civil proceedings, those are absent. And once we start reforming our law to include such rules, that will also act as a conscientizing tool to ensure that the legal practitioners are informed of these responsibilities. And that will help us to transform our legal culture, which is very much ableist as well. We, much like some of the other presenters here in South Africa, they've highlighted legislation around terms such as imbecile and idiot are still retained in South African law as well. So the law is the problem, the lack of training is the problem, and then the unaccommodating court rules remains a problem as well. Then the question from Dr. Muzata on defining sexual abuse and rights to sexual reproductive health rights. I agree that the issue is always around consent. And if we have laws that indicate that some people are incapable of consenting to sexual intercourse because of their disability, we start facing a problem. When we start reforming those laws indicating how people can indicate their consent or that they are not consenting to sexual intercourse, and if we have such an understanding, then we will be better placed to interrogate instances where consent is absent. And that's why comprehensive sexuality education is an important tool, not just for children and parents, but in the justice system as well. Thank you.
Thank you so much, Valine, for that. So I'm going to go back for another round of questions. So I think, Harry, I'll come to you first, and then I'll go to Ali from there. And then there's another question in the chat box, which is a follow-up, I think, to what you were speaking about, Valine. And the question is, how do or should we decolonize the teaching of disability studies? And that's the one question for you, Valine, sorry. And then, so Harry, please go ahead with your question. I hope that we will be able to hear you this time.
Sorry, colleagues, am I visible?
Yes, we see you very well. Thank you.
All right, thank you.
Oh, okay, Harry, we still cannot hear you. May I suggest that you type your question in the box and I'll read it out for you to the presenters. Maybe let's go to Ali. Ali, are you able to ask your question now? Okay. Harry, can you speak now?
Hi.
Now we can hear you. Please go ahead.
All right. Well, thank you very much. My apologies. I joined a little bit later, but I will frame my question in such a way that it's quite general. Any of the all of the presenters can respond to that. My interest is basically on the issue of intersectionality. I think this is an area that the CRPD Article 25 is quite silent. And also looking at the African optional protocol on disability, that one is also quite silent on the same. Not to mention, of course, not to undermine the fact that Article 6 of the CRPD does make reference to the multiple forms of discrimination that women face. But then the issue of intersectionality approaches and the like do not come out that strongly or clearly or visibly, so to say. So I wanted to learn from the presenters that have presented here, and maybe anyone else who is participating in this conference, to say, what are the best practices like? Are there lessons that we can learn from your respective jurisdiction to say if if your states or countries have adopted any intersectional approaches to the guarantee of the right to health vis-a-vis sexual and reproductive health for persons with disabilities, for women and girls with disabilities in that regard. And what is the potential now from a doctrinal perspective that intersectionality theory would have within the African context to prepare or to spur the full realization of the right to access to sexual and reproductive health services and information for women and girls with disabilities. Thank you.
Okay, thank you so much, Harry. For the sake of time, I think I'll just take one more question, and I'll apologize in advance for it because I'm going to murder the pronunciation of his name, his or her name, Tijweza Chombumbi. I'm so sorry. I'm not sure how to pronounce that correctly. Please go ahead and ask your question, and I'll ask you to just keep it brief. Thank you. I don't know if you're there, Mr. or Miss Chombumbi, TJOMBUMBI. Okay, so I'm not sure if you're speaking, but we can't actually hear anything. So I'm going to hand over now to the presenters just to answer the questions that have been asked. Thank you. Please go ahead, anyone who wants to start first.
Hi, Diana, thank you so much. The question around decolonization of the curriculum in relation to disability. So we know that we have a disconscious ableism in our curriculum in our law schools. So we have a lack of exposure and critical engagement on disability by academic staff in their curriculum. So when we have laws, for example, around identifying imbecility and idiocy, as depriving people of their legal capacity. And we don't have academics that are questioning these discriminations in our laws when they're teaching these laws, and they teach them as a matter of course. These are the court rules, and this is how we proceed without any critical engagement. Then they have been colonized by this disconscious ableism that permeates our law curriculum. So access to justice, of course, should be implicit and explicit in the teaching of law in our law schools. So this not just includes academics, it also includes clinicians. So our law clinics, for example, offering services to indigent persons, including those with disabilities, are those law clinics providing services that are accessible to their clients with disabilities? Are they training the aspirant attorneys to provide services to clients with disabilities? So a few years ago, I looked at the curriculum in a law school, and I found that there was absolutely no engagement, bar a few examples where people considered what clients with disabilities may need when it comes to representation in court proceedings and how the rules and other procedures affect them. So this colonization then is relevant as well, specifically because we are in a world where we've had this moral anger around the decolonization that is necessary in our tertiary institutions on the continent, generally speaking. But then we also forget that our students with disabilities have also been colonized by not just Eurocentric and global North ideas around what it means to have a person to have a disability and to engage with legal systems. But we also continue to have tertiary institutions that are fighting a lot of outside and external influences, such as funding constraints, for example. And now with the COVID-19 pandemic, this remote teaching also impacts on services provided to students with disabilities, and then those outside of the institutions, such as clients with disabilities that are not able to access law clinics because they don't have data, for example, or they can't physically access the clinics anymore. So there's a lot around what our curriculum can do, not just in content, what the law should look like for inclusivity on disability, but also how we can better serve persons with disabilities. Thank you.
Thank you so much, Ms. Holness. I don't know if any of the other presenters would like to add anything. Would any of the other presenters like to add anything, or? All right, so thank you also very much. I do hate to cut this short because it is a very interesting conversation, I think, that we've been having. But for the sake of time, we do have to conclude at 4:30 South African time. And we've already cut into our health break. So I do apologize for the session going over. But may I ask if anyone still has a question that we have not been able to address here with everyone, please make use of the chat function. And can I ask the presenters to respond to any of the questions that are put in the chat box so that at least people get a response to their answers. I would propose that we take a quick 5-minute health break. We do have to stand up and and stretch our legs. I'm cutting it short from 10 to 5 minutes because we have run out of time. But at least 5 minutes to stretch our legs should get us ready for the final closing session of the day. And just to remind us all, tomorrow the conference will be continuing, and we have once again an exciting lineup of speakers for the second and final day of the conference tomorrow. So let's take a break and be back at about 10 to 4, please, South African time. Thank you.
Hi. Hi, everyone. Welcome back. I hope we are all back from our health break. It's just 5 minutes. I think I'm sure by now we are fully energized to conclude the session for today. I see the sign language interpreter is with me, and so I will assume that we are good to go. So a warm welcome to everyone, and I would like to thank you for sticking with us thus far. It's been a long day so far, and I will also want to welcome you to the fourth and final plenary session of day one of the 9th Annual Disability Rights Conference. So the title for this plenary session is Safety Issues and the Sexual and Reproductive Rights of Persons with Disabilities. For this session, we have two speakers. Our first speaker is Advocate Barbara Lamara. And Advocate Lamara will be discussing a study on the realities faced by women with mental disabilities in accessing family planning services in Uganda. The study was jointly prepared by Advocate Lamara and Dr. Ojo Patrick, who is a senior lecturer at the Department of Special Needs, Yambogo University, and Ms. Patricia Atim Podong, who is an assistant lecturer at the Makerere University School of Law. But Advocate Lamara will be presenting the paper on behalf of the team. Our second speaker, Dr. Simon Peter, will be speaking to us on a paper titled On Yet Under the Radar, Sexual Behavior and Outcomes Among University Students with Disability. In a nutshell, Dr. Peter will analyze how university students who may not have previously assessed or received sexual and reproductive health education navigate their way through the higher education system that in a way exposes them to an increased level of freedom in managing their own affairs. So let me quickly introduce our speakers. Our first speaker, Advocate Lamara, is an advocate of the High Court of Uganda who works with Mental Health Uganda. She works specifically with this organization under the project called Access to Health is My Right. The project focuses on the promotion and protection of the rights of homeless women with mental disabilities on the streets of Kampala. Advocate Lamara also serves as the Vice Chairperson, Advisory Committee of the Network of Public Interest Lawyers, which is an umbrella of lawyers that promotes social justice and public interest litigation in Uganda. Advocate Lamara holds a Bachelor of Laws degree from Makerere University and a postgraduate diploma in legal practice and legal aid from the Law Development Center in Uganda. She is currently pursuing a postgraduate diploma in project planning and management at Uganda Management Institute. Our second speaker, Dr. Peter, is a lecturer in the Department of Educational Foundations, Management and Lifelong Learning, School of Education, University of Dar es Salaam in Tanzania. He holds a PhD from Kenyatta University in Kenya, and Dr. Peter's research interest is in the field of special education, disability rehabilitation and management, curriculum designing, adaptation, and teaching strategies for children with diverse learning needs, and ICT and special education. Dr. Peter is an active member of the International Association for Special Education and African Network for Internationalization of Education. So just to quickly give the basic house rules, because we are running out of time and we are a bit behind schedule. Our speakers will talk to us for about 15 minutes, and then hopefully we have around 10 minutes to entertain questions and get feedback from our speakers. So without wasting too much time, I would like to call on our first speaker, Advocate Barbara Lamara, to make a presentation. Advocate Lamara, please take the floor.
Hello from Uganda. I hope I'm being heard loud and clear.
Yes, we can hear you loud and clear.
I've already been introduced, so I'll go straight to my presentation. It's an honor to present this paper today. I'm presenting it on behalf of the team that was earlier mentioned. I can authoritatively say that Ms. Patricia's team is following on YouTube right now. We were inspired to do this paper because of the nature of work that I do. Like as earlier introduced, my day-to-day work involves interacting with women with mental disabilities living on the streets of Kampala. As such, this research was informed by the huge gap that many of these women face.
I'm so sorry, madam. I can't hear you well. I'm not so sure whether your mic is too far from your mouth or what. I'm not so sure, but I can't hear you well.
Okay, can you hear me now?
Yes, we can. I think it's better now. You can just move closer to the computer. Thank you.
Okay, sorry about that. Yes, so I was saying the research was informed by my day-to-day work. My work involves interacting with women on the streets of Kampala. Those are women with mental disabilities who live on the streets of Kampala. So because of the interactions that we usually have, we realize that there's a huge gap these women face while trying to access sexual and reproductive health services. What I can mention before the presentation is that originally we had intended to conduct an empirical study, but due to the delays in the process of obtaining ethical clearance, we decided to do a doctrinal study. So this is mainly a doctrinal study with a few experiences that we have had, but then we don't mention, we try to keep away with the names because we didn't.
I'm so sorry again, madam, please. I'm not so sure, maybe it's the background or what. I cannot, I can hear your voice and some of the words, but I can't hear you. And I'm not so sure whether it's only myself who can't hear the speaker well. I'm not
maybe
so sure.
I'll try to be slower.
Yes. Oh yeah, let's try that and check.
Okay, let me be slower, then you can tell me if you're not hearing so that I don't talk to myself. I'm sorry about that. Yes, so I'll go straight into the presentation. So we start by defining what amounts to good sexual and reproductive health. And we use the definition that was given by the United Nations Population Fund, that good sexual and reproductive health means a set of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity in all matters relating to the reproductive system and to its functions and processes. So we note that access to family planning services is a key aspect of actually good sexual and reproductive health. And it's very prudent for us to observe that sexual and reproductive health is also an essential part of the universal right to health and to the highest attainable standard of living. I hope I'm being heard. Yes. So family planning services are essential for guaranteeing equality between men and women. When you look at what the United Nations Working Group on Discrimination Against Women in Law and Practice says, that only women can become pregnant, a lack of access to contraceptives is bound to affect their health. During the International Conference on Population and Development, that was in 1994, states acknowledged the innate link between women's health and access to family planning and other reproductive health services. And in 2015, we see that the United Nations General Assembly endorsed these commitments and adopted the 2030 Agenda for Sustainable Development, for the Sustainable Development Goals. And we note that under Sustainable Development Goal 3, which provides for good health and well-being, we see that target 3.7 is on the right to, is on ensuring access to sexual and reproductive health, including information. It's also key to note that women with mental disabilities experience high risks of being denied very many human rights, including access to family planning services. In a report by a special rapporteur on the rights of persons with disabilities, concern was expressed on forced contraception methods that are imposed on girls and women with mental disabilities without their consent, often as a means of menstrual regulation. And all these practices, of course, are contrary to their human rights and, of course, violate their right to life and a number of rights, since the rights are interrelated. I hope I'm being heard loud and clear. So basically, the importance of family planning services, as highlighted by the United Nations Population Fund in 2019, it notes that 63% of women between 15 to 49 years who are using some form of contraception method had their lives improved, and the positive impact was seen on the quality of their lives, since they could decide on how many children they could have. And according to this report, we see that this in turn positively influenced their enjoyment of other rights, such as the right to work, right to health, right to education, among all the other rights. So when we look at the situation in Uganda, we looked at a 2016 report by UBOS, which is the latest report. It stated that 12.4% of the Ugandan population lives with some form of disability. And the report indicated that disability was more predominant among women, that's 15%, than men, which was 10%. And another thing that was noted in the report was that women with disabilities usually suffer the double drawbacks connected to gender and disability. That is, they suffer issues like sexual and gender-based violence. I hope I'm being heard. Yes, and also inadequate access to sexual and reproductive health rights. Like I had earlier said, women have unique rights, and we see that actually more women look for sexual and reproductive health rights compared to the men. So that drawbacks are actually double when it comes to women with disabilities, because they already face discrimination because of their gender, and then at the same time because of the disability that they have. I'll delve into the legal framework. Yes, the legal framework protecting the rights to sexual and reproductive health of women with disabilities, mental disabilities in Uganda. Like I earlier said, in Uganda, we don't have a specific act that talks about sexual and reproductive rights, but then we have a number of laws that, if broadly interpreted, would mean the right to sexual and reproductive health. Since human rights are interrelated, let's say interdependent, and let's say indivisible, we give them a broad interpretation for a right to mean a different right. Because for one to enjoy, let me say, the right to life, they have to be able to enjoy their sexual and reproductive rights. So I start with international law. We looked at the Universal Declaration of Human Rights, specifically under Article 25, that guarantees the right to a standard of living adequate for the health and well-being of an individual. Like I earlier mentioned, sexual and reproductive health rights are vital in realizing the highest attainable standard of living of all persons, including persons with mental disabilities. The second law under international law that Uganda has also ratified is the International Covenant on Civil and Political Rights. Basically, I'll just be mentioning the article to be a little faster. I looked at Article 6 that guarantees the right to life, and Article 7 that talks about freedom from torture, cruel, inhuman, or degrading treatment. Like we earlier said, very many women with mental disabilities face coercive practices like forced sterilization, and that is also, it could amount to torture, like I said, if broadly interpreted. The next is the ICESA, that is the International Covenant on Economic, Social, and Cultural Rights. I beg your pardon?
Just to quickly say that you have about 7 more minutes, just to inform you of the time. Thank you.
Okay, thank you about that. So the ICESA, Article 12, recognizes, it obliges state parties to recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. And in 2000, the Committee for Economic, Social, and Cultural Rights, under General Comment 14 to Article 12, expounded on the scope of the right to the highest attainable standard of health and stated that ensuring reproductive health care is the core obligation of the human right to health and reproductive health services, and therefore must be provided through primary health care systems. Yes, so the next convention that we looked at that Uganda also ratified is the CEDAW, that's the Convention on the Elimination of Discrimination Against Women. Article 16 of this convention guarantees women equal rights in deciding freely and responsibly on the number and spacing of their children. And Article 10 further states that women's rights to education includes access to specific education information to help ensure the health and well-being of families. Further, under General Recommendation 24 by the CEDAW Committee, states should prioritize the prevention of unwanted pregnancies through family planning and sex education. Goes directly to the CRPD, which specifically talks about the rights of persons with disabilities. We specifically looked at Article 6 that notes that women experience various forms of discrimination, and therefore the CRPD calls upon state parties to ensure that they enjoy the rights and freedoms fully and on an equal basis with others. It's also very important to note that when you look at this article, it recognizes that women have the double drawbacks of, let's say, by being women, they already face that discrimination, then on top of that, they are disabled. So we see that the CRPD also recognizes that. Article 12 further calls for the recognition of the legal capacity of persons with disability to exercise their will and preferences without undue influence. This includes deciding on their sexual and reproductive health rights. The next provision that we looked at was Article 23 of the CRPD that provides for matters of the family and home, including the rights of persons with disabilities to freely and responsibly decide the number and spacing of their children. When you look at Article 23, it largely draws from the standard rules on equalization of opportunities for persons with disabilities, which calls for the full participation of persons with disabilities in family life, and also puts an obligation on states to promote the right to personal integrity for persons with disabilities and to ensure that laws do not discriminate against them with respect to sexual relationships, marriage, and parenthood. We cannot also ignore the CRC, the Convention on the Rights of Children, because we also have very many girls with mental disabilities. And Article 24 of the CRC protects the rights of girls with mental disabilities to obtain the highest attainable standard of health. And we see that the Committee on the Rights of the Child has explained that family planning services should be situated within comprehensive sexual and reproductive health services, and should include sexuality education, including counseling. Contraceptives and family planning goods and services must also be available in sufficient quantities and include a wide range of contraceptive methods, such as condoms and emergency contraception, accessible in a physical, economic, and non-discriminatory manner for all girls, and both in the rural and urban areas. So we see that under international law, the right to sexual and reproductive health rights for girls in Uganda, girls and women in Uganda with mental disabilities are actually guaranteed. Under regional laws, we look at some, just a moment, we look at the African Charter on Human and People's Rights. So the African Charter protects women's sexual and reproductive health rights. And Article 16 in particular recognizes the right to the highest attainable state of physical and mental health. So since we say human rights are interrelated, we see that the Charter actually guarantees a number of rights that can broadly be interpreted to include sexual and reproductive health rights. Article 18, Clause 4 in particular recognizes the rights of persons with disability to special measures and treatment in accordance with their physical and moral needs. Shall look at the Maputo Protocol, that is the protocol to the African Charter on Human and People's Rights and the Rights of Women in Africa. Article 14 is very specific on health and reproductive rights, including sexual and reproductive health rights. Article 23 of the Maputo Protocol recognizes the rights of women with disabilities, thereby recognizing the dual marginalization that women with disabilities face on top of being women. The African Charter on the Rights and Welfare of the Child.
Can you hear me?
Yes, I can hear you.
Your 15 minutes is up, but I can give you 1 or 2 minutes to just give you
basically, okay, thank you. So we looked, of course, at the domestic laws. The Constitution guarantees the right to sexual and reproductive health rights. The Persons with Disabilities Act, which is a new act, 2020, does the same, and the Mental Health Act of 2019 also. So the experiences that we got from women based on our interactions and this study realize that many women experience negative attitudes from health workers when they try to access the sexual and reproductive health services. There's also a lot of stigma and negative social norms from society and the communities within where they live. We have many experience in accessible medical facilities in terms of accessibility and transport and all that. Then lack of privacy and limited access to information. We have lack of access to community-based reproductive health care services because the kind of women that we deal with, those are women with mental disabilities, would rather have community-based services than actually access some of these facilities which have a lot of stigma and negative attitudes. Another experience that many women face, most of them come from poor backgrounds and indigent. So there's a lot of poverty that hampers access to healthcare, and many of them are vulnerable to sexually transmitted infections, for example, HIV and AIDS, because they live on the streets and usually are homeless. They don't have a home to stay in. And so many cases of abuse, let's say rape, go unreported because many of them fear to access even the police. And usually the police also doesn't understand cases reported by women with mental disability. So you find so many of them are single mothers, and usually they are not even sure who is responsible for the pregnancy, or they know the person responsible, but the person does not want to come up and take responsibility. So there is also interference with legal capacity and decision making in terms of substituted decision making instead of letting them have supported decision making. Then limited budget allocation for mental disability issues in Uganda. About only 1% of the budget is allocated to mental health. Basically, the recommendations that are run through very fast. This is for the government, especially the Ministry of Health, to monitor and evaluate whether women with mental disabilities are receiving adequate and appropriate services. Then also in-service training for healthcare providers so that they can know how to handle women with mental disabilities. Then raising awareness in communities. This will go a long way reducing stigma that many of these women face. Improving accessibility of health systems and services. Then budgets must be realistically made. And then provision of basic education to women with mental disabilities on their rights, especially in terms of sexual and reproductive health services. And then also, I was supposed to earlier mention that Uganda hasn't ratified the African Protocol on Disabilities, so also it could go a long way if Uganda ratifies the protocol. Then addressing poverty through various economic empowerment programs. It seems that many times when these women are empowered, at least they have some confidence and some independence to make some of the decisions on their own. So another is ensure provision of community-based mental health care, and then jurisprudential consolidation in terms of judicial activism. We mentioned the laws, but we haven't seen many of them being applied in our courts. Then another is support initiatives towards supported decision-making instead of substituted decision-making. So basically, in conclusion, we can see that ensuring equality of access to sexual and reproductive health services for women with mental disabilities calls for more than just legislation against exclusion from services, but it calls for taking more positive measures to ensure that these women are indeed able to benefit from the services. Thank you for listening. Sorry, I had to run through the presentation, but I hope you'll be able to hear me. Thank you so much.
Thank you very much, Advocate Lamara, for taking us through the experience of the average woman with mental disability in Uganda. So the importance of access to family planning as a key aspect of good sexual and reproductive health. You have highlighted that for us, and you have also made us understand that there's no specific national legislation in Uganda that is in place to really address this peculiar plight for women with mental disability. And I think you have also been able to make us understand some of the experiences of women with mental disability, like negative attitude from health workers, which is probably very surprising. And then there's the general stigma and negative social norms in the society, as well as other issues like lack of community-based facilities for women with mental disabilities. We have also listened to some of your recommendations, crucially training for healthcare providers and public orientation and awareness to sensitize the public, and as well as the political will to ensure that there's an appropriate budget to really take care of women with mental disability with respect to access to family planning services. Thank you very much, and we hope to hear from you during the question and answer session. I would like to invite our second speaker for today, Dr. Simon Peter, to talk to us about his paper on Yet Under the Radar, Sexual Risk Behavior and Outcomes Among University Students with Disabilities. Dr. Peters, you can take the floor.
Okay, thank you very much, Chairperson. This is Simon Peter, not in the Bible, but this one is from Tanzania. So, hope you can hear me. You can hear me well?
Yes, we can.
All right, thank you. My study, actually, today's paper, I don't know whether if I can share with you.
Yes, you can, if you want to, please.
Okay. All right. So today's paper, what I want to present today, as the chair said, the title is on yet under the radar, the sexual risk behavior and outcomes among university students with disabilities in Tanzania. This study was motivated by the fact that for the past 10 years, Tanzania witnessed the rapid increase of universities, both public universities as well as private universities. For example, 10 years ago, we had only 3 universities, 2 public universities, and actually 1 private university. So then after 10 years, we have more than 48 universities. So you can see the rapid increase of universities in the country. Having a rapid increase of universities in the country translates to the high enrollment of students at university level. However, the services provided among the special needs groups, they're not commensurate with the increased number of students with special needs. So this is the main focus of this study, that we have increased number of students. However, we don't have services to support their unique special needs, diverse needs. So to start with has been increased incidence of young people engaging in sexual activities and the spread of sexually transmitted infection, STDs, as well as AIDS, HIV/AIDS. And the concern that there's a concern for the sexual and reproductive health for persons with disabilities in this age group, 15 to 24 years, has increased in recent years, especially in Tanzania. So there's been a tremendous increase in the number of universities. As I said, we have increased number of universities in the country. Also, we have increased enrollment of students with disabilities compared to the 10 years ago. So students who may have not previously accessed or received any sexual and reproductive health education from medical personnel, parents, teachers, religious leaders, as well as actually they are considered in the country, they are considered as taboo. So these students, they are exposed where they have freedom at university compared to the secondary school, primary school, for the first time when they have freedom, but however, they didn't receive any sexual and reproductive health education in their prior level of education. So for decades in Tanzania, primary and secondary curriculum did not reflect the unique needs of the persons with disabilities. Also, there's a lack of health education professionals in schools, especially private, primary, secondary schools. Number of studies have shown that persons with disabilities are more likely to be sexual assault, especially rape and other sexual assault. And also they tend to be victims of STIs, sexual transmitted infections. Consequently, persons with disabilities may further experience the disability-related stigma or shame. So finally, risk-taking behavior is an inherent part of the students' disabilities experience. This study, given the fact that I mentioned multiple factors in the country and across the globe, which may lead persons with disabilities to experience different sexual behavior and educational needs than their counterparts, students without disabilities. That means that persons or students with disabilities, they are more disadvantageous compared to their colleagues who are not, who don't have disabilities. Also, lack of empirical information on the sexual health behavior of persons with disabilities in universities is another gap which leads researchers to do this study that provide at least empirical information on the status of sexual health behavior among persons or students with disabilities in universities in Tanzania. Furthermore, there's a little research on how to help universities to become more attractive and specific to this section of the population. So there's a little research where how we can help universities to be attractive, especially to students with disabilities. Participants in this particular study were about 5,243 students between, students who were admitted between October 2019 to October 2021. So this study was conducted in one of the universities, the oldest university in Tanzania, University of Dar es Salaam. And all the students undertook the study voluntarily. And the certified sampling was used to enroll students according to gender, discipline, and education level. Here we explain that students, actually, the respondents who are stratified were grouped according to their gender, as well as subject discipline, as well as education level at university. So the findings of this study, the major finding actually, this study found that the sexual health behavior among students with disabilities is heterogeneous, that they are not homogeneous, that they have different needs, sexual and reproductive needs. And these heterogeneous needs, they are likely driven by the heterogeneous disability experience among themselves. For example, this study found that students with partial sightedness or blindness may have increased rates of STIs emerging from barriers to becoming integrated in the informal care. So this section of the population, students with blindness, they have increased rates compared to the other group of students with disabilities. Also, students with multiple disabilities, this study found that they engage in certain sexual behavior. For example, they had higher number of sexual partners, and also they reported that they are not using condom during the sexual intercourse. Also, this study found that friends or partners influencing one to behave in a given manner. They responded, they came up with this, they reported that it is their friends as well as all partners who influence their sexual behavior. Also, they study recommend that this section, students with special needs, they need attendant care to receive protection. Because I think now that most of the universities, especially the university I'm conducting the study, they don't have the attendant to take care of their sexual and reproductive health education. Also, the nature, students with physical disabilities, they argue that maybe they're experiencing high rates of sexual and reproductive incidences because of their physical defenseless, and their partner, they are taking advantage of their disability. To conclude, Mr. Chair, I've recommended possible intervention to address these issues. One is to provide specialist sex education or counselor through one-to-one individual tailored services according to one's needs. As it is now that yes, universities have counselors. However, most of these sessions, they are not tailor-made. Actually, the way they conducted that, they don't include the special needs of students with special needs. Actually, they don't have experience or they don't have idea how these special groups that have different needs. Also, another recommendation is to improve peer education to young people, especially students with special needs. Also, I recommend the parent training for parents or guardians and sex education. And finally, is training in learning disabilities for peers that place priority on risking of using appropriate media about sex and sexual sex. To conclude, Mr. Chair, this study found that yes, there's an increased enrollment of students with disabilities for the past 3 years at university. However, the diverse needs and outcomes are not taken in place. Actually, they are not taken when they are enrolled in that university. They are put in one basket. However, so therefore, the university dean of student office should increase availability of programs as well as services that are inclusive and accessible to all students, including students with special needs. Finally, sexual behavior, this study found that they are heterogeneous and likely attributed by heterogeneous disability experience among these special attendees. Thank you, Chair.
Thank you very much, Dr. Peter, for your presentation, and thank you for sticking to time. So you have taken us through this very interesting scenario where we have students who are not really prepared for the free world, if you like, as we have in the higher institution. And then you have also told us some of the findings of your study, which reveals that there's some sort of disproportionate effect with regards to students with disability when it comes to sexual risk behavior and the need to really grant educational policies in the higher institution in such a way that it addresses the unique need of students with disabilities in the university. I can't really see a lot of questions in the chat box, and I think Advocate Lama also said she need to attend to an emergency. But maybe I can just quickly ask you, Dr. Peter.
Yes.
So, what do you think in all of these? Where exactly do you see the role of international human rights law, for example, with regards to addressing this peculiar issue? And maybe there's like one or two instruments that you have in mind. Then the second thing that I would like to know, I would like to hear your thoughts on is, now we're looking at a situation where the big cross here is the fact that these students, they get into the university without any sort of exposure to sexual and reproductive right, education. So can we not also take a look at addressing this issue beyond the four walls of the university? So for example, maybe also talking about how parents need to prepare their wards for what is obtainable or what might be obtainable when they get to that stage of education. I would like to quickly hear your thoughts on that.
Thank you, Chair. With regard to international, hope you can hear me. Yes, with regard to international human rights law, yes, as a country, we assessed the number of them, both international and regional human rights instruments. Also, we domesticated some of them, and we have domestic laws, like currently we have two. We have Sexual Offense Special Provision Act of 1998, as well as we have Persons with Disabilities Act 2010. However, this, for example, this 2010 is more than 10 years ago. So in that particular Persons with Disabilities Act 2010, it guarantees that any education institution, including universities, they are going to provide supporting services to these students with special needs. But when it comes to implementation, most of the time, actually, during my study, the service is not there. It's not available. Actually, the service is too general that didn't take into consideration their unique needs. Also, I agree with you that parents, yes, they need to prepare their children. We cannot leave everything to universities or what. So this is very important. That's why in one of the recommendations I say parents and guardians, they need also train how they can handle the matter. Thank you.
Thank you very much. Just a quick observation. I don't think we have our sign language interpreter. Okay, I think they're back now. Thank you very much for that. Thank you very much for your answers, Dr. Peter. Unfortunately, Advocate Lamala has to quickly excuse herself because she had some emergency to attend to, and I don't think she has been able to join us. And seeing that we've also been a couple of minutes behind schedule, I want to once again thank you all for staying with us till the end of this session for today. This will mark the end of day one of the the annual Disability Rights Conference, and we hope to see you all tomorrow by 10 o'clock South African Standard Time for continuation of this robust engagement as it relates to the sexual and reproductive rights of persons with disability. Thank you very much.
Thank you very much. Bye.
Thank you. Bye.
Bye. See you tomorrow.